Just a quick disclaimer, the views expressed today are from Giovanna and my experiences over time and not necessarily representative of our firm's views. Briefly, the firm, Hamilton, Brooks, Smith & Reynolds, is an IP boutique, which means our services include procuring and protecting our clients' rights under patents, copyrights, trademarks, and trade secrets. The firm has 2 offices, one in the Seaport District of downtown Boston and one in historic Concord. Giovanna and I are 2 of about 30-something practitioners. Our attorneys are skilled and knowledgeable in major engineering, applied sciences, and life science disciplines, as well as those evolved non-traditional technology areas, too many to list here. My particular background is in software engineering. I have prepared and argued patent applications in examination in the U.S. as well as abroad. I also prepare and file copyright applications for software products, as well as advise on software license agreements, due diligence, and IP portfolio management, especially in the software and computer-related industries. I'm so pleased to co-present with Giovanna. She's one of the firm's leading attorneys with software expertise. I'll turn the mic over to her to finish some introductions and introduce our topic for today.
I just wanted to tell you a little bit more about Mary Lou because she is an unbelievably accomplished and she's also very humble. Mary Lou is a pioneer in the software patenting and open source licensing industry. She has groundbreaking experience in open source licensing and software patenting in representing Lotus, for example, with protecting their spreadsheet technologies in the 1980s. I'm very fortunate to have the opportunity to work with her for over a decade, and I'm thrilled to be presenting with her today. Just a little about me. I have a computer science background with Java programming experience in the software industry. I'm a patent attorney with expertise in open source licensing and blockchain technologies. Today, we're going to go over the key goals for software companies who use open source. We're going to be explaining these key goals and talk about how you can achieve them. By the end of this presentation, you will have a clear understanding on how you can try to maximize the value of your patented software innovations using open source licensing. Now, with open source licensing, we want to have these key goals in mind, and this is what we'll be going over today. You want to make sure that you maintain the ability to deliver your product. You're going to want to make sure you protect your software from devaluation and from intellectual property. You want to protect your intellectual property from devaluation. You want to mitigate any software vulnerabilities when you use open source. That's always a major issue. And you want to control your contributions to the open source community. You don't want them to be inadvertent. And you want to avoid exposure to copyright trolls and use open source licensing to increase your market share and interoperability using different licensing schemes like dual licensing. And we're going to go into detail about that today. Now I'm going to hand it back over to Mary Lou, who's going to explain the trends in the industry, beginning with a historical perspective.
Thank you, Giovanna. Let me start by setting a stage here. Let's ask the question, what is the state of open source software as a technology, as a business community with business models of their own, as well as a set of rules and laws that govern our activities in this area? Over the next few slides, I will answer that question as we take a look at various trends where OSS has had an impact. To begin, take a look at the trends in technology. Software is pervasive and affects many industries. Pick a field and follow the historical development of innovations in that field, and you'll quickly converge on software. Here's some examples that I quickly came up with. In the field of agriculture, you have Eli Whitney invents the cotton gin. A century later, we have John Deere's motorized farming equipment and machinery. Fast forward to weed-resistant seeds and irrigation systems controlled by software. So pick another field, medicine. We have Gregor Mendel discovering genetics in his vegetable garden, to the days of leech therapy and the use of plant medicinals. Fast forward to digital radiology and robotic surgery. These are two areas where I and the firm have prosecuted many patents since the mid to late 80s. A next example, how about the field of transportation? We have the Wright brothers flying machine, and that was the phrase used as the title of one of their first patents because the word airplane did not yet exist in the dictionary. And then the development of the steam engine and other locomotives. Fast forward to electric rail systems, of course, controlled by software. And what would Mr. Ford think of today's automobile developments and innovations, from his Model A solution to the then horse and buggy pollution problem? Well, to today's fast forward hybrid and electric cars and soon to be autonomous vehicles literally driven by software. One last example, the electronics and communications industry. We have come from the days of telegraph to telephone to you can tell the world through the internet. Now transact business with virtual currency, not just implemented by software, but specifically written in OSS. So software and OSS run throughout many industries and impact many industries. So as we reviewed each industry's evolution in technology, I couldn't help but think of the whole new business areas and business models that followed. This is certainly true with e-commerce outgrowing traditional retail sales and virtual currency leveraging off of that. So this next slide, let's review and contrast those traditional business models with the current trends of business models and IP portfolios. In a traditional IP portfolio on the left, one generally leans more or less equally on copyrights, patents, trademarks, and trade secrets, and then licensed patents, copyrights, and trade secrets as made business sense for royalty stream production or business partnering. We use patents to capture and protect novel and non-obvious engineering contributions. Patent rights are procured through a governmental application process, country by country. Trademarks protect your business signature, any identifier that identifies you as the source of certain goods or services, such as your trade name, your domain name. Color schemes like the John Deere color scheme are trade dress, and one procures these rights by use in commerce. There is a governmental registration process that can deem qualifying trademarks or service marks as incontestable. Trade secrets are based in contract law through the use of agreements to keep confidential. This form of IP protects against misappropriation of company business plans, data, methodologies, or techniques that give the company an edge over their competition. Copyrights protect original works of an author, capturing an author's expression. These rights exist upon the work product being in a fixed medium. In the software arena, here's some examples of what I mean by fixed medium and the existence of copyright. In the higher level programming languages, source code is considered a literary work. And so that's fixed in a fixed medium and copyright attaches. Run that source code through an interpreter or compiler, and the resulting object code of the software deliverable is also considered to be in a fixed medium where copyright attaches. So copyright, like patents and trademarks, give exclusionary rights to the IP owner. An owner of a U.S. patent has the right to exclude others from making, using, selling, or importing the patented item into the U.S. A trademark owner has the right to exclude others from diluting or misusing his trademark or service mark, or effectively using the mark, passing themselves off as the trademark owner. A copyright owner controls who is allowed to make copies, distribute copies, or make derivative works. And we'll use that concept sprinkled throughout some following slides. So keep that in mind with the OSS licensing. Over time, Giovanna and I have seen a shift in IP portfolios. There's a blend of the traditional patent, copyright, trademark, and trade secrets but with a balance of the OSS licensing and proprietary licensing. And we'll elaborate on that balance as we progress through the slides. So one more trend I think that is helpful in this IP picture. We have seen in IP enforcement the historical view something like this slide. Prior to the 1990s, software patents and copyrights saw a fairly synonymous amount of infringement lawsuits. It was difficult at times for certain digital works to enjoy copyright protection under the language of the law, but the Digital Millennial Copyright Act around 1990 helped to better define copyright protection for the digital production area of software, that is, digital audio, digital video works. Also, the Copyright Act was changed to include mask works from the semiconductor manufacturing arts. So by the 1990s, we had increased patent infringement and copyright infringement enforcement activity on computer-related innovations. The patents infringement enforcement activity for software innovations, however, outpaced copyright infringement lawsuits for software works due to patent trolls, or NPEs, and that stands for non-practicing entities, as owners of patents who exercise that right to exclude others. NPEs took stock in how pervasive software is and asserted those patent rights throughout various industries. In recent decades, more towards the right-hand part of the graph, patent infringement litigation of software patents has slowed down, fallen off of that spike in the 90s, and this is largely due to the U.S. Supreme Court decision on patent-eligible subject matter. So defendants against NPEs counterclaimed patent invalidity, which was especially effective on many software and computer-related patents. Also, about this time frame, the America Invents Act brought about another venue besides the courts to review validity of a U.S. patent. And this is known as the PTAB. It's a review board at the Patent Office, and that is another part of our services is these post-grant review processes. So to complete this IP enforcement trend picture, look to the far right of the graph. We have seen a rise in OSS compliance litigation. So this has creeped into the picture for software and computer-related industries. And with this backdrop of trends, we understand software and OSS in particular has a growing impact on many, if not most, fields of technology, as well as impact on IP portfolios and enforcement activity. So here's tip number one for the day. As industry players shift their business models and IP portfolio to include more OSS licensing, we should expect to be more vulnerable to OSS compliance challenges and litigation. So we need to be prepared and on top of our OSS compliance steps. So let's take a look at some implementation steps of compliance policies and procedures. As we said, a copyright owner enjoys the right to control who is allowed to make and distribute copies and who is allowed to make derivative works. OSS is a licensing scheme or approach that gives up some of these traditional rights under copyrights. Different OSS licenses give up more or less of these traditional rights under copyrights. The GPL on the left of this graph is considered copyleft, opposite from traditional copyrights, because it is a form of licensing where the author gives recipients of the work permission to freely make and distribute copies and to freely make derivative works, provided that any resulting copies or derivative works carry the same terms or compatible terms of the license agreement. So in effect, that means the goal of the GPL or copyleft licenses is to ensure that each redistributor downstream enjoys the same rights, and thus the more restrictive terms out of the possible OSS licensing. In implementation, the author makes the source code available to each downstream author, as well as making each downstream author under the same obligation. So 2 points of compliance under the GPL are to give attribution of each author in the redistribution chain and to make available the source code. So other OSS licenses are more permissive, meaning each downstream author or redistributor is allowed to remove some of these rights. This is conceptually opposite to the GPL goal. And examples of the more permissive types of OSS licenses are the MIT or BSD licenses. These licenses do not require the next downstream redistributors to pass on the same license terms and oftentimes do not require making the source code available. So between these two extremes, the copyleft or reciprocal licenses on the left side to the more permissive OSS licenses on the right-hand side, there are intermediate levels of freedom to redistribute and access source code. So Giovanna, let's drill down and review some tips on compliance with the more restrictive or copyleft type of OSS licenses.
So there are two types of open source licensing to be concerned with. One would be the inbound licensing, and then the other, of course, the outbound licensing and compliance. In our experience, outbound licensing compliance is an important focus for our clients because that's where they tend to be the most vulnerable in terms of legal exposure. Most of the software license compliance obligations kick in upon distribution of the software, and that's why any software being deployed outside the company should be cleared for third-party license compliance. Many companies will structure their software implementations so that although the company relies heavily on open source code, they only use that code on their servers and their backends, and therefore no open source code is actually distributed outside the company. By using this technique, by only using the open source software on the server side, you would most likely not have to adhere to the burdensome disclosure requirements by, for example, the GPL for most of the licenses in the GPL family. That would be with the exception of the AGPL, which does not require distribution for it to kick in. Because license compliance litigation is on the rise, we advise our clients to be extra sensitive to outbound software licensing compliance. To help ensure compliance, it's important to provide open source licensing education and training for your engineers. Everyone involved in the coding process should conduct due diligence to identify, track, and manage any third-party open source code. Likewise, it's important that every seller in your supply chain also ensures license compliance. We see the most success when you make software clearing an integral part of the software development process. You want to consider, for example, getting code scanners for looking for copyleft code or using services like, for example, Black Duck. They can provide software clearance. Generally, in software, there are two types of licensing. There's proprietary and open source licensing. In open source licensing, a licensor surrenders some of their intellectual property rights. Often, these are rights to access, use, and modify the source code. With a proprietary license, the licensor typically retains their intellectual property rights, often the copyright of the source code and its patent rights. Now, dual licensing. Some of the most successful licensing strategies lately have been dual licensing models in software. Dual licensing enables the distribution of software under a proprietary licensing model as well as an open source licensing model, allowing the licensor to simultaneously leverage the advantages of both types of licensing. One well-known example of dual licensing is Oracle's MySQL database management system. They license it both as a proprietary license as well as under an open source license. To give you a couple of examples of the open source licensing, consider, for example, there's some recent litigation with Hancom and Artifacts. In Artifacts licenses a GoScript product, and they did a really good job of dual licensing. GoScript is a free open source PDF writer that Artifacts owns and licenses under the GPL version 2. It also licenses a GPL-free proprietary version that you can buy. Now, Handcom, a competitor, incorporated the GoScript tool into its suite for document management software. Handcom incorporated it without Artifact's permission. Now, since Artifacts had licensed it under the GPL, that would have been fine. They could have used, Handcom could have used the software without Artifacts' permission under the GPL, but it would have needed to comply with the GPL requirements. And Handcom did not comply. Handcom did not, for example, disclose the complete and corresponding source code and include a copy of the GPL with its distribution of the GoScript product. Consequently, Artifacts filed a federal copyright action for breach of the GPL version 2. And in a historic ruling, a federal court found that the GPL version 2 was an enforceable contract against Handcom. Now, this litigation just recently was settled at the end of last year, but it brings to light the dual licensing model that ultimately allowed Artifacts to have the upper hand in licensing enforcement against a competitor. By integrating dual licensing into its software business model, Artifacts was able to increase interoperability with its GoScript product while asserting control over non-GPL distributions of its software. In another example of dual licensing, consider, for example, you have a smart appliance like a Nest thermostat or a smart printer, some type of smart appliance. And in order to recognize your device using, for example, the Linux operating system, you would need a driver that was compatible with Linux, the Linux kernel. And because your driver is interfacing with the kernel, it would be licensed under the GPL. So that's just a real easy situation where you would definitely want to license your software, your driver software, under the GPL because it's going to be a Linux driver. Now, with respect to dual licensing, you could license your smart device's specification protocol or the API that's used to interface with your smart device, or, for example, the SDK kit that you use to create apps that are compatible with the smart device. So if you license that spec and that SDK kit under the GPL version 2, for example, you can create a situation that induces others to create GPL version 2 software that's compatible with your smart device. At the same time, you can make your smart device specification, API, the SDK kit available under a proprietary license in order to create a direct line of revenue. Now, often some of my clients tend to come to me right before they're going to release their software product, and that can be good and bad. I mean, bad because we may need to replace code that's in the distribution, in the anticipated distribution, to ensure proper licensing clearance, and that can be tricky, doing it right before it's supposed to be released. Now, it's good only because if they haven't released the code yet, oftentimes patent rights are still available, and we can file for patent protection. It's important to file early and often. And there are ways, if you have a new product that's about to be released, there are ways to file like a patent application economically. For example, a provisional patent application that covers all the potential implementations that are going to be represented in your product. And so you would want to kind of cast a wide net with your provisional application to include all the innovations. And you would want to do that as soon as possible before you release your product. And before releasing your product to the public is one of the best times to file, so don't miss that opportunity. Okay, so one thing that many people mistakenly believe is that open source licensing your software creates a bar to patent protection. And that's not true at all. Most open source licenses provide a very narrow grant, a narrow patent grant. With the GPL variants can provide a much wider patent grant that is a little bit harder to decipher the scope of. Now, let's look at some different flavors of patent grants in open source licenses. So with the broad grant in the GPL, it would require a patent grant for any license, for any patents that would be implicated by the whole program. Now, let's say you only made a small contribution to the program. That would, under like the Apache, for example, then your patent license would only go for that contribution that you made. But under the GPL, version 3, for example, it would, your entire portfolio would be licensed if it was implicated by the whole program. So if you made a small, narrow contribution, but the whole program was a much more massive piece of software that was part of a much bigger picture, and you had patents that could be implicated in that entire program, you would effectively be giving a license to that implementation. So that's something to be sensitive about and be careful with.
So I think if I interject here, Giovanna, it bears kind of broadening the picture here on the patent grant. So since the GPL3 has a broader patent grant that reaches past the one portion of the OSS code and applies to an entire software product, this may have a rather large and disturbing impact on a company with a sizable patent portfolio. I think that's a restatement of how you pose this. And so we do counsel our software clients that have grown a patents position over time to be sensitive to broad patent grants in OSS licenses such as the GPL3. I might also add that we may raise the patent grant clauses of a client's OSS licenses during a patent portfolio review or in our steps in managing that IP portfolio.
Thank you, Mary Lou. This next slide is just some examples of the exact language that you have in the Apache and GPL version 3 license. For example, the Apache provides a grant, an irrevocable grant to make, use, or sell the work, which would be your contribution under Apache.
So I have to comment that that specific wording of the Apache 2 license agreement does follow the U.S. Patents Act, stating that the patent owner has that exclusive right to make, have made, use, offer to sell, or import. It's almost like a copy-paste straight from the Patent Act. And so I can sum this up as another one of our tips of the day, where we need to be cognizant that the patent grant of an OSS license is very much clause or license specific.
Thank you, Mary Lou. Another interesting thing about open source licenses as they relate to patents is they also provide, some of them also provide patent retaliation clauses. A patent retaliation clause allows a licensor to retract their granted rights from anyone who, for example, initiates litigation. So this would allow the licensor or the distributor of the software to use their patents to defend against any aggression. The GPL version 3 and the Apache license 2.0 both include patent retaliation clauses. Now, the GPL version 3 and the Apache 2 are examples of open source licenses that have explicit patent licensing clauses. Now, arguably, the other open source licenses do include an implied patent grant. For example, open source licenses like the GPL version 2 or even the BSD grant permission to use and redistribute the software. And this permission can be interpreted to imply that you're also granting patent and copyright rights. So let's talk about some examples of patenting open source technologies. Now, Red Hat, for example, has over 1,000 patents, and that's a pretty healthy patent portfolio. And Red Hat, not only does it have a very healthy patent portfolio, but it's also one of the largest providers of open source software. Another space where you have a lot of patenting and open source issues, and this is more something that we'll see in the future, is with blockchain technologies that are using the major blockchains like Ethereum, Hyperledger, and Bitcoin. All three of those blockchain platforms are open source, are based on open source technologies. And they, for example, Hyperledger and Ethereum, I think they both have white papers and notices, I think one of them on their GitHub, that speak about how any decentralized apps that are running on the system will also need to be open sourced. And they're defining, I think they're still deciding on what types of licenses that they're going to use. It could be, there's discussion about whether it'll be GPL version 2 or Apache. Please.
Yeah, I think that further illustrates how effective setting oneself up for dual licensing in your IP portfolio. So that's another tip of the day from us, is just to not overlook how we are filling in that balance between the traditional patents and proprietary licensing with the use of, on the other hand, OSS licensing and that dual licensing approach for your IP portfolio.
Great. Now that brings me to, why would someone want to patent an invention that's going to be distributed under an open source license? Well, we talked a lot about dual licensing strategies using, for example, the GPL version 2. Now, as I mentioned, the GPL version 2 comes with some strings, some compliance strings attached, some compliance obligations. So if you offer your patented software under GPL version 2, while also offering a proprietary license to that software, anyone that uses your GPL version of the software are going to have to comply with the various requirements of the GPL version 2. So that would require them potentially to also have to disclose their source code that interfaces with your source code, assuming that it's tightly coupled with the GPL version 2 software. And so, for example, if a competitor were to take your open source software that's licensed under the GPL and integrate it within their system and distribute it, they would have to comply with the GPL by potentially including a copy of their own code as well as your code, and they would have to include the GPL version 2 license with the distribution. So these are steps that oftentimes companies want to avoid because they don't want to have to disclose their source code, for example. So they'll come to you perhaps for a proprietary license so you can secure that revenue. You also you can use your patent rights against redistributors who are non-compliant with the GPL. And with the dual licensing models, you ultimately can license the patented software to create a revenue stream. So patents provide your company with a solid competitive edge that can help your company carve out its technological space in the marketplace. And patents can be used to position your company and attract investment or acquisition. So it's an immensely valuable part of your company's portfolio. Now, today, Mary Lou and I covered trends in the industry, the issues involved with open source software licensing, and we talked about dual licensing strategies. And as legal professionals, we, with a tremendous amount of experience in this space, before you distribute your software product, we urge you to inventory your software code for software clearance purposes, to file for intellectual property protection and file early. Work out a licensing strategy to determine if you can benefit, for example, from the dual licensing strategy approach. And contact intellectual property counsel to assist. I mean, it's really important that you have proper counsel who advises you in a prudent way that optimizes the value of your intellectual property. We would like to be helpful, and we look forward to partnering with you. So in that vein, please feel free to reach out to Mary Lou or me if you need any assistance with your patents or your licensing. Thank you so much. And now we're opening up the webinar for questions.
Great. Yep, here's the first question. I am a developer of software and don't have any OSS policies in place. What initial steps should I take? I'll go ahead and answer that one, Giovanna. So while you're working on getting these OSS policies and procedures in place, here are some basic first steps. Audit your work for potential innovations. And out of those potential innovations, prioritize those, apply for provisional patent applications as early as you can on those higher prioritized innovations at least. And then posture yourself for dual licensing, one of the tips of the day that we were mentioning. So have an OSS audit conducted on your software so that you can meet compliance, as well as highlight patent grant clauses. And with that in hand, get a patent attorney to help you with these steps. And I think those are some basic fundamental first steps, self-help that you can take, and then get your patent attorney in the picture to take the next steps from there. Another incoming question. I'm not familiar with what was said about OSS audits and what should I expect from an audit. Do you mind if I answer that one, Giovanna? And then
please, feel free.
Thanks. So software development inventories from an audit, and these are per component usually, will identify for you each component, including any proprietary code and external code, third-party open source components used by the subject software. Also identified will be any open source software license or third-party license that's applicable to the external code. Typically, the audit will provide you with the HTTP link to the specific license. And also, the audit will show whether the component was modified. The audit also provides a source address URL where the code for the component can be found. And usually one last line per component in the audit will give a short description of how that subject software is used. It'll say something like server-side scripting, running HTTP servers on devices. It's fairly short and to the point. So in that vein, we think of this as a software development inventory, and that's what you should expect from an OSS audit. We have some other incoming questions. Here's one. What is the viral aspect of the GPL? Do you want to take that one, Giovanna?
Sure. So the GPL family of licenses are known to have a viral component. There's many types of the GPL. There's GPL version 1, GPL version 2, GPL version 3, the AGPL, and the lesser GPL. Now, the lesser GPL has the viral component is dampened a little bit, but it still is there. So with the viral component, basically, if you have GPL license code that you are integrating with your own software, depending on how you integrate that GPL license code, it can cause your software to also have to be licensed under the GPL. So if the code is tightly coupled, the GPL code is tightly coupled to your code, then there is a good chance that you would have to license your own code under the GPL. And so that's something that companies and their engineers need to be very sensitive of, because you need to make sure you have the necessary separation between the GPL code and your proprietary code in order to protect your intellectual property rights. And that's something that we work with our clients on. We'll help them go through the code and make sure that we have the necessary separation And sometimes, code has to be rewritten in order to make this happen. So it's something that we can assist you with, and it's something that is important in order for companies to help maintain and protect their intellectual property rights and not inadvertently cause their code to be licensed under the GPL.
Great. Thanks, Giovanna. Another question. Is there a trend in SaaS, software as a service, to rely on trade secrets rather than patents for IP protection? And I'll answer that one. I've not seen the trend in that area relying toward trade secrets. I still have clients that would use traditional patenting to cover, at least from the user interface perspective, and all that is being exposed to the end users through that SaaS. And from that perspective, there's some ripe areas for patenting to protect because the exposure leaves the door open to reverse engineering. And once reverse engineered, the trade secret will no longer be a secret and not have the protection in place for the owners, the proprietors. So I still, in the SaaS platform, do encourage our clients to look towards patent protection rather than trade secret protection.
Great. I've got another question here. How a patent might be commercially monetized to blockchain, for example, Ethereum, which is GPL open source. So essentially the question is, how can you monetize a patent that is directed to an open source blockchain implementation? Okay, so first, with most of the open source licenses, the patent grant covers your contribution. So if you have a software program that's running on a public blockchain like Ethereum, a dApp, some middleware, your patent grant would be limited to that specific implementation that you implemented in your decentralized app, your dApp. And then if what the concept in the inventive concept in the patent, a good patent will cover lots of different implementations within a single idea. So your particular implementation for your decentralized app, that's just one example implementation. The idea in your patent presumably should be able to be implemented in other languages, in other programming languages, like Ethereum, for example, has its own programming language. So if you were to rewrite your program and capture your inventive concept in another language, in another blockchain protocol, another platform, that patent grant that you provided for your Ethereum implementation would not run to some other implementation that is unrelated to the source code that you licensed under the GPL to Ethereum. So ultimately, your patent grant is very narrow and generally, and so it's to the specific implementation. It's implementation specific, and patents cover many different types of implementations. So you're only providing a patent grant for that specific implementation that you have contributed and open source licensed.
Perfect. That leads right into, maybe it's the same person asking this question. Can you provide a brief summary of dual licensing? So in summary, kind of leveraging off of what Giovanna just said, patent rights cover that engineering concept that may be implemented in software, many implementations, firmware, hardware and software, maybe a specific ASICs. So a lot of those different implementations are covered under the patent rights. One single implementation may be coded in OSS. So that one particular version of software is licensed under OSS, while the other implementations that the patent reads on are covered under a patent license. So that's what we mean by dual licensing, being able to have both of those activities active in your IP portfolio. Next question.
Sure, I've got one. If we have patents on source code intended to be open source, is GPL version 2 the way to go? Okay, so essentially, is GPL version 2 the way to go for patented open source software? So I think depending on your strategy, you would want to pick, depending on your licensing strategy, GPL version 2 may be appropriate. I think it's particularly appropriate in where you want to increase exposure and interoperability with your software product. And so you would create a GPL version 2 implementation of your software and share that with the community, and try, by providing that, then hopefully there are others that will build on that and create other components that could be used with it, maybe plugins, all sorts of things. So you get the benefit of having the community, the software community developing around your software when you make it open source under the GPL version 2. So you get those benefits. But at the same time, if a competitor wants to repurpose your source code and include it in their software product, then you can offer a proprietary version that they can license it to you, that you can license it to them under, or they can opt to take the GPL version 2. And if they don't comply by, for example, distributing their source code with it and including the GPL license, if they decide to use the GPL version, then you have potentially an action against them for noncompliance. And you can also raise it with the open source community, the Software Freedom Foundation. They will go after players in the software community that are not complying with open source licenses. So you may be able to have the benefit of working with them because they want to ensure software client compliance. So I think GPL version 2 provides a good way of dual licensing because it has some teeth attached. It has some compliance obligations, and that's a way that if a competitor, for example, uses your code and doesn't comply, then that gives you a way to some recourse.
Okay, a couple more questions incoming. I'm reading through. The open source definition, Article 1, says basically that no royalty shall be when software is distributed. And some argue that this makes OSS incompatible with FRAND, your fair and reasonable royalty licensing, where patents might exist for industry standards. And what do we think about this statement? So OSS is going to be software version specific, that one implementation, where there's many other implementations that are meeting the industry standards and thus fall under some patent coverage. So when looking in that light of the specific code version that's being covered and licensed, I think the OSS can coexist with the FRAND licensing activities. I don't necessarily think that it's incompatible as far as the OSS activities, and there are times where the interpretation of open source definition is the word free does not necessarily mean $0 money. It means freedom to have access to the source code and be able to modify that without recourse of copyright, speaking about derivative works. So I think some of the premise of the basic statements here is not always a jump to saying no royalty on as far as the open source definition is concerned. There are some, I'll say, over time evolved OSS licenses that do make that more clear as far as the royalty stance. Okay, next question.
Yep, we've got a question here. We often deploy a dual licensing strategy for our software, and we also file patents on open source software. In your opinion, do you think a patent's commercial enforceability is weakened if the code is made widely available in open source? So a couple of things. So one, if you are licensing your software under an open source license that has like significant compliance obligations, like the GPL version 2, then maybe you wouldn't be suing for patent infringement, but you could you have the leverage of compliance litigation, and compliance litigation is on the rise. Competitors are going after their other players for non-compliance. And so that's something that you would think of as an alternative. But in terms of whether the patent is weakened, I think that it's possible that that there would be some not necessarily weakening, but the value could be decreased in somewhat because you are providing a license to a particular implementation of that software under open source. So there is some erosion of intellectual property rights there. You are providing a license. But I recommend, for example, using the dual licensing strategy with a license like the GPL version 2 in order to provide another mechanism to put pressure on others that are using your source code to make sure that they are using it in a compliant way. So it gives you another approach, and that's just the mix of what companies are doing now with their intellectual property portfolios. Open source licensing is becoming a valuable part, and it can help supplement the entire portfolio to make it stronger.
Great. Thank you. Perfect timing, because I'm keeping an eye on the clock. So we've run out of time, but thank you for those questions. And there's a few others that offline Giovanna and I hopefully can catch up with. Also, you will be receiving a copy of the slides. And just in closing, I'd like to sum up the three major tips that we made today. Tip number 1 was OSS compliance challenges are on the rise, therefore be prepared to be in compliance. Tip number 2, embrace the OSS environment along with the traditional patenting and take advantage of dual licensing. And tip number 3, in OSS, the patent grant is OSS clause specific and license version specific, so involve your IP practitioner there. Thank you for your time. Giovanna, do you have any closing remarks?
Just feel free to follow up with us. We would love to partner with you and be helpful. Thank you so much.